Welcome to Public Enemy Number 1, the police whistleblower. Please keep in mind that throughout this series, I may be mentioning domestic violence, sexual harassment, and sexual assault. If these topics are stressful for you, please take care. I will also be discussing moral trauma and institutional betrayal in policing. If these issues cause you stress, please take care as well. If you haven't had the chance to do so, please visit my website, policeversuswhistleblower.ca. That's policevswhistleblower.ca, where all of the public documents and published legal decisions are available for viewing. While you're there, please sign up for my newsletter and I'll keep you posted when I publish new episodes of the podcast or when I have upcoming court appearances. I said last time I would be picking up at June of 2017, but I had missed a crucial part of my story. In early 2017, my PTSD symptoms had become severe. If you're like me, I was always able to handle a very high level of stress in my life. So this was the first time that I was genuinely experiencing a mental health injury. And for someone like me, I didn't pick up on all the warning signs until it became too much. So as I mentioned, I had been relegated to administrative duties and I was working on a desk in the basement of headquarters. And I was actually putting out some of my best work. I really didn't want the police service to see that they were getting the better of me. So I was proactively going through all of our old training material and updating the statutes, correcting errors. I had begun to collect statistics during use of force judgment scenarios so that we could look for areas that needed improvement and focus on that with our training material. Anyways, it was about February of 2017 that the stress just became too much. I had 3 panic attacks in 1 week in February, and I didn't know what they were at the time. So anybody that's had a panic attack will know that everybody reacts differently to them, but for me, it felt like I was having a heart attack. So I wasn't doing anything stressful at the time. I think I was doing laundry in my home, and it just came on out of nowhere, and I literally just had to sit on the floor in my hallway for about 45 minutes, waiting till I could regain my breath. It felt like someone was sitting on my chest, and I was at the point where I didn't know if I needed to call 911. I did visit the emergency department that week, knowing that my health wasn't well, but I didn't really know what was going on. But in doing so, I was able to get the assistance of a psychiatrist and later a psychologist and begin to start my PTSD treatment. So it was at that time that I began a medical leave of absence and filed a workplace injury form with WSIB. So for the period from February until June of 2017, I was on a medical leave of absence. So during that time, I began to research the prevalence of whistleblower retaliation in policing in Canada. And what resulted from my research was what I was calling at the time a research paper, but I compiled a list of cases from across Canada where other police officers had done exactly what I had done. They had witnessed something they thought was wrong. They'd reported it, whether that was, racial harassment, gender harassment, excessive use of force, you name it. There had been a lot of police officers before me that tried to call out wrongdoing and were punished as a result. So the more I researched, the more I became discouraged that I would be able to stay in the profession and try to make a difference. When the class action was launched, that's when I knew that I had an opportunity to resign on my own terms. So from the months of May to June, I began to plan out my resignation, what I would do after my career in policing. And I knew that it involved advocacy and trying to change our laws as they were, because they were not adequate in protecting victims of domestic violence at the hands of police. Let me tell you, even though I did love the profession, because of what they had done to me, it felt really good to drop off all of my equipment at headquarters on the day that I resigned and put it all behind me. I had decided that what I was going to do after resignation was start my own corporation and my dream was to provide whistleblower program administration to government and private organizations. 3 weeks after I resigned, I released the systemic misfeasance in Ontario policing and the coordinated suppression of whistleblowers. As I said, I didn't know what to call it at the time, so I was calling it a research paper. And I did get some media attention at the time. People were very interested in the concepts I was identifying in this research paper because they weren't things that we typically discuss. We don't openly discuss internal abuses of police powers. As I've said before, that's primarily because of the secrecy. Police officers are not allowed to talk about anything that they witness internally. So the public are not informed about the state of policing in Canada. But this was my way of saying there's a lot more than meets the eye. And because of that research paper, people wanted to know more. I was asked to speak at conferences across Canada, and throughout the fall of 2017, I traveled from Edmonton to Newfoundland, sharing my story and educating people on why we need whistleblower protection. I told you about my WSIB claim when I was working. Well, what that meant was that the Workplace Safety and Insurance Board of Ontario had been paying my salary up until the day that I resigned because of my workplace injury. But beyond resignation, they were still going to be paying for my medical care. And that was very important to me because resigning from my employment meant that I wouldn't have any medical benefits anymore. And at the time, I was a single mom of 3 kids, so losing my income and losing my benefits was pretty significant for me. I had to ensure that I would at least have the medical care in place so that I could work towards recovery and not let it negatively impact my family. Now, as 2017 went along, my health was improving a lot. I was under the care of a psychologist and I was taking medication, but slowly over time, all of my symptoms started to fade away. I no longer had insomnia, my appetite had come back, and I was exercising regularly. In September of 2017, I revisited the Waterloo Regional Police Services Board and presented a delegation yet again. This time, I sat at the board table and I explained to the board that they really needed to pay more attention to ethics at the police service. A year earlier, the police service had proposed an ethics policy, and at the time, the chief, Mr. Brian Larkin, said that he would take their recommendation under advisement for the future. I complimented the board on their attempt to initialize an ethics policy, but I stressed to them the importance of their adequate oversight. Once again, they didn't have any questions for me, but I was happy that I reattended because, again, I needed them to see that they had not gotten the best of Kelly Donovan, and there was still a lot more to come. Now, I'm going to take a little pause just to do a little recap, because at this point in time, in the fall of 2017, I had given up my profession. I had about 24 years remaining as a police constable, but I had walked away and given it up to start a career as a whistleblower advocate. This really should have been the point in time where my story ends. But I'm only on episode 2, and I probably have another 8 episodes to go. So clearly there's a lot more to the story. What I've described as the ongoing whistleblower retaliation I still face today began around December of 2017. So I've told you about the class action lawsuit that Waterloo Regional Police was facing. I didn't mention that the Waterloo Police Association was also named as a defendant in the lawsuit. And in December of 2017, Chief Brian Larkin provided a sworn affidavit in defense of the class action lawsuit. As you can imagine, Larkin was swearing to the fact that there was no harassment at the Waterloo Regional Police Service. He was defending his employer, the very same person that oversees his performance as chief of police and decides how much he's paid or gets in a raise every year. Larkin provided additional information in his affidavit. What he called was a chart of information that he had HR provide that outlined 5 female officers at the police service who had filed human rights complaints against them but those complaints had been resolved successfully. Among those female officers, one was listed as a female constable who filed a human rights complaint against them, who was paid a monetary settlement and resigned voluntarily. That might not mean anything to you right now, but I knew in reading that Larkin had been disclosing details of my resignation agreement, which he was contractually barred from doing. It is arguable, and it hasn't been proven in court, whether or not it was significant information to identify me, but I believed that it did, and I believed that it constituted a breach of our contract. What I didn't know at the time, but I found out later in 2018, was that in January of 2018, so just a few weeks after Larkin's affidavit was published, the Waterloo Regional Police Service appealed my WSIB claim, the claim that was only paying for my medical care for my PTSD. These actions exacerbated my moral trauma. The police service did not have to include me in their defense of the class action lawsuit, and they surely did not need to file an appeal of my WSIB claim. I believed that these actions were personally targeted with the intent to cause me harm. So despite the fact that my health had been improving throughout the fall of 2017, I began a very slow downward spiral in early 2018 due to this whistleblower retaliation. Because I had been so vocal about the problems in policing in Ontario, I had registered to speak at the Ontario Legislature in February and March of 2018 as the government was considering a rewrite of the Police Services Act. Justice Tulloch's report had been released, and it recommended protection for police whistleblowers. This was the first time that government had paid any attention to the fact that police whistleblowers don't speak up because of fear of retaliation. I outlined this when I spoke at the Ontario Legislature, and it again seemed to be a new concept for lawmakers that this was something that was necessary. When I shared my story, it was almost unbelievable to them that I could have faced such harsh reprisal at the hands of a police chief after reporting what I believed were internal abuses of power. Although not all of my recommendations were implemented, I still feel as though my presentation made a huge difference during that Police Service Act rewrite. And police officers were now allowed to complain, which sounds ridiculous, but they were also provided a certain level of protection from reprisal when they do report misconduct. It wasn't perfect, but it was a start. Throughout this time, I didn't really know what to do about what I believed were breaches of our contract that was signed when I resigned. But I had this overwhelming feeling that if I didn't stand up for myself and I didn't try to hold them accountable, that they would continue to come after me for the rest of my life. I contacted my association about the police service's conduct, and they advised me that I should file an application at the Human Rights Tribunal for contravention of settlement. But I didn't understand why this was their advice. I hadn't settled my human rights claim. I had withdrawn it as a condition of my resignation. My human rights claim had never even been heard. And my resignation agreement settled several different processes. The human rights complaint was just one of them. So I disagreed with the association. I didn't feel that this was a matter that should be before the Human Rights Tribunal. Either way, they wouldn't be representing me in that matter. That was just their advice, was to do that on my own. I hadn't given up 24 years of my policing career to stress about a lifetime of retaliation by the police service. In May of 2018, I filed a very simple statement of claim in civil court against the Waterloo Regional Police Service for breach of contract. As some of you would expect, the police service immediately notified me that they would be filing a Rule 21 motion to dismiss my claim. They were alleging that court did not have jurisdiction of my claim, that there was no reasonable prospect of success, or that it was frivolous or vexatious. Basically, anything they could allege they were, because they wanted to have it dismissed out of court. Now, this is the part of my story where things get really strange. 51 days after I filed my civil claim in court, the Waterloo Regional Police Service filed a case against me at the Human Rights Tribunal of Ontario, alleging that everything I had said publicly about policing was a breach of my resignation agreement. Now, I'm going to ask you to read between the lines on this one. If I was contractually barred from speaking publicly, would it make sense that I was so brazenly and publicly talking about my experiences working for the Waterloo Regional Police Service? I would hope that by now you've established that I am a reasonable, somewhat educated individual. So I'll let you decide that on your own, but as the story continues, you will learn a lot more. The case that they filed against me was about 500 pages long. It included every page from my website printed out, every public speaking engagement I had done. My 93-page report was included in their complaint. They had simply alleged that any time I mention them publicly, I am violating the agreement. I immediately filed a request to dismiss their case with the Human Rights Tribunal, advising them that there was nothing in the contract preventing me from speaking, that what I was saying was in the public interest to be known, and that I didn't think the Human Rights Tribunal had any jurisdiction over their claim. Their claim was essentially a claim for defamation filed at the Human Rights Tribunal. Despite me making this request to dismiss their case, the Human Rights Tribunal sent me a letter advising that their case was going to be scheduled for a hearing. I didn't feel I was being heard by the tribunal, but I knew that I would be prejudiced if their case proceeded to a hearing ahead of my civil claim that I filed ahead of theirs at civil court. I didn't think I was given any choice, so I filed my own contravention of settlement application at the Human Rights Tribunal of Ontario. I told them, if you're going to hear their claim, then you have to hear mine at the same time. It's just not fair to do it any other way. But because of this, I now had to fight a two-front war. I had to make submissions to both the civil court and the HRTO about the same matter. And this dragged on throughout the fall of 2018. As a result of all this additional stress and pressure, my health really started to spiral downward. I started sending emails to the tribunal asking for additional extensions of time to file paperwork because I simply wasn't well enough to do it. My health had deteriorated so much that I was assessed at Homewood Health Centre in Guelph, and they recommended that I attend the inpatient program for PTSD. It just wasn't a reality for me because, again, I was a single mom to 3 kids. I had bills to pay, and I simply couldn't just take a 30 to 90-day break from life. As I had had to do so many times before, I had to just suck it up and soldier on, so to speak, because I had to get through this. I didn't have an option. It was actually during my assessment at Homewood Health Centre that one of the psychiatrists talked to me about my options. And when I told him that I knew about this law that we had, the Courts of Justice Act, Section 137.1, it was Ontario's anti-SLAPP law, and it prevented somebody from being gagged by a lawsuit if they were advocating on behalf of a matter of public interest. And when I told him about that, he said, well, what's stopping you from trying it in your case? And although I knew that the law was intended to apply to civil lawsuits, I didn't see the difference between that and the case that the police service had filed against me. Their case was alleging that I had breached our agreement. They were asking for significant damages. They wanted me to stop speaking about them, stop selling my book, and even stop operating my business because they felt that I was trying to profit off my experiences with them. This psychiatrist was absolutely right, and I went home and contemplated why I didn't have the courage to just go ahead and try. So over the next few weeks, I prepared what I thought was a motion in civil court, but I was educated by the staff at the Toronto Courthouse office. They advised me to file an application because this hadn't been tried before for a tribunal proceeding. So I filed an application to dismiss the tribunal proceeding in accordance with Courts of Justice Act, Section 137.1. Because they didn't really know how to handle it, we went through 3 separate chamber appointments until finally in January of 2019, the matter was heard before Justice Favreau. She is now a justice for the Court of Appeal for Ontario. This was the first time I presented on my own behalf in front of a judge in Ontario. And I think I was extremely lucky to be appointed a female judge, and I'll tell you why later on. It did make a difference. But Favreau took the time to really understand what the issue was. And she took the time to ask clarifying questions to make sure that she truly understood my legal arguments. Having to go through this process was extremely stressful, but I felt like it was my only hope because the HRTO was not listening to my request to dismiss their case. I thought this was my only chance. But during this time, in the winter of 2019, I barely had any time at all to even catch my breath. The hearing of the motion to dismiss by the police service was being heard in February, and I had a lot of work to do. Justice Favreau's ruling was released on February 1st, 2019, and I had lost that application. She had ruled that Courts of Justice Act Section 137.1 does not pertain to a tribunal application. I understood her ruling because I knew this was the first time anyone had attempted what I had done. But she recognized the fact that my arguments had merit. She didn't rule on whether or not the Police Services Board was an attempt to gag me, but she did identify that there were concerning aspects to my case. And she also noted that if the police service had brought their case before civil court, it would have been a different story. If I could go back in time today, I would have appealed that decision, because I do feel that it's important that Courts of Justice Act Section 137.1 applies to a lawsuit brought in any venue. Lawsuits don't have to be civil court lawsuits. There are many ways that lawsuits can be filed against individuals. And in this modern day of administrative justice, more and more lawsuits are being brought before tribunals as opposed to civil court. It's time for that law to change. The police service's motion to dismiss my civil claim was heard on February 13th, 2019, I believe, and all issues in their motion were fully argued before Justice Doi. This was my first time appearing before a male judge. I definitely did not have the same experience as I did speaking before Justice Favreau. It was clear to me in Justice Doi's ruling that he had given significantly more weight to the arguments of opposing counsel than little old self-represented me. Justice Doi had ruled to dismiss my civil lawsuit in accordance with one aspect of their motion. He agreed with the police service that my case didn't have any prospect of success, but he specifically mentioned in his ruling that he did not feel the need to address any other grounds raised by the police service. Now, up until this point, I had been arguing that the HRTO proceedings should be put on hold in favor of procedural fairness to allow me to proceed with my lawsuit. But at this point, it was pretty difficult for me to argue that, seeing as how my lawsuit had been dismissed. But it wasn't only procedural fairness. I had several issues with the way the HRTO was proceeding with our cases. In January of 2019, when I was in and out of court, I became increasingly suspicious of the HRTO. I couldn't understand why some of my emails were getting lost, and they were simply refusing to address my request to dismiss the police services case against me. One day, I performed a simple Google search of the name of the registrar of the HRTO, and what I found was pretty mind-blowing. He had come to the HRTO from the Ontario Police College, where he had held the post of general manager and chief instructor. When I looked up the job description for those positions, it was obvious that he would have had regular contact with members of the Ontario Association Chiefs of Police, and at the time, Chief Brian Larkin was the president of the OACP. And not only that, he would have had regular contact with police leaders about curriculum being delivered at the police college, not to mention that they second senior officers from police services to teach. Tribunals Ontario has conflict of interest rules, and the rules are pretty clear. It says that if a member has had any prior involvement with a party in a case, they cannot participate in the processing of that application. But in my case, the registrar had not recused himself at all. And when I went back to my files from 2016 and 2017, it had been the same registrar participating in the processing of that application. Now, I'm not sure if you know, but policing is one of the highest rates of complaints when it comes to human rights violations. Yet the person appointed to the position of registrar should have technically recused himself from every application involving police. I found this to be very strange, and I addressed it in an email to the tribunal in February of 2019. But not surprising, the email was not received by them, so I sent it a second time. But once my lawsuit was dismissed, I knew that the HRTO proceedings had to go ahead. So I provided the tribunal with all of my submissions. And included in there, I outlined my allegations against the registrar and the adjudicator for alleged conflict of interest and favoritism towards the police service. For those of you who don't know, when you have an allegation such as this against an adjudicator or the tribunal in general, the advice is that you have to take it up with the adjudicator themselves. So my only recourse for this was to ask the person I was accusing to be favoring whether or not they were in fact favoring. So as I've said a few times, 2018 and 2019 were very intense years. I was just trying to keep my head above water with my PTSD, but I had all of these demands for documents and requirements to submit paperwork to court. I filed to appeal Justice Doy's decision, and that appeal was scheduled for October of 2019. But before that, pretty much out of the blue, the HRTO issued an interim decision in my case in September of 2019. There wasn't really anything to decide at this point in time. I believed we were just waiting for them to schedule a hearing date. But this decision was very defensive. The adjudicator was appalled that I had accused her of violating their code of conduct. And she wrote in her decision that if I continue to say these sorts of things, she will deny me my ability to defend myself in the police services case, and they will simply move to the decision on remedy. The one thing in this decision that I thought was, I guess, laughable, but it's pretty obvious when you read it, is the adjudicator states in the decision that if I want to question the constitutionality of the proceeding, I need to bring it up in civil court. I guess she didn't read the email where I submitted to her my anti-SLAPP application decision from civil court, which was my only way to question the constitutionality of the proceeding. I was starting to accept that this was just the way I was going to be treated throughout this proceeding, and I would have to get used to it. I did still file a formal complaint about the conduct of the adjudicator and the fact that the registrar was in a conflict of interest. But I didn't have high expectations that anything would happen. I think now's a good time to have a discussion about access to justice, because I've been asked dozens of times since 2017 why I don't just go and hire a lawyer to represent me. Well, if you have any idea about the cost of litigation, and especially litigating a police service, you would understand why it simply was cost prohibitive for me. At this point in time, about the middle of 2019, I was made aware of how much the police service had spent to date on their legal counsel in my matters alone. In around June of 2019, I was made aware that the police service had spent approximately $250,000 since the date of my resignation on their legal counsel. So if you can imagine, I had left my career in policing. There would have been absolutely no chance of me coming up with $250,000 to pay a lawyer so that I could try to hold the police service accountable post-resignation. I don't know how anybody could hold me responsible for the fact that I just didn't have that kind of money. The police service, on the other hand, had the unlimited purse of the taxpayer. And this really was only the start of it all. I brought this figure to the attention of the HRTO because I had initially argued when the police service filed their case against me that they had done so out of retaliation. The Statutory Powers and Procedures Act says that if a case is brought in bad faith, the tribunal, I'm trying to think, I don't know if it's shall or may, but the tribunal can dismiss the case. So previous to this, I had pointed out to the tribunal that they had brought their case 51 days after mine. They had printed out all of the evidence to include in their case in the month of June. It hadn't been prepared ahead of time. And it really did seem to me that the only reason they were bringing the case was to aggravate the entire situation and cause me to retreat and give up on my lawsuit. Well, now I also had the legal figure. So I drafted an email to the tribunal in July of 2019 to show them how much the police service had spent on this matter. Now, keep in mind that the police service was spending money on legal fees in my case because they filed an appeal against my WSIB claim in January of 2018, and there were ongoing issues processing my WSIB complaint month by month. But the reason I believed these figures were evidence of retaliation was that in the month of April 2018, they only spent $686. Then I filed my lawsuit on May 9th, 2018, and all of a sudden they spent over $16,000 in the month of May and more than $13,000 in the month of June, and their case was filed against me at the end of June of 2018. I believed it was strong enough evidence to suggest that they filed their case out of retaliation, but I still didn't get a response from the tribunal. And as I said, none of these submissions were referenced in the September 2019 decision. The adjudicator had decided in that last decision that we would be proceeding with 4 matters only, and she didn't cite my request to dismiss the police services case, so it appeared that I would never be heard on that issue. So we were back to waiting for the HRTO to schedule a hearing for our cases against each other. And I spent the rest of the summer preparing for my Court of Appeal appearance scheduled for October. Now, remember how I told you that I filed a formal complaint about the registrar and the adjudicator? Well, the response I got to that came on October 11th, 2019 at 10:01 a.m. Now, why is that significant? Because that was the day I was scheduled to appear at the Ontario Court of Appeal at 10 a.m. So the very minute I should have been taking the podium, I got an email from our Attorney General simply telling me that it's a matter I have to take up with the adjudicator themselves, and he referred me to file a complaint with Tribunals Ontario, which is what had started this entire process. Now, I truly hope that if you're still listening to this podcast series, it's because you also have an interest in government accountability. And let me tell you, I publish every letter I receive on my website because I truly believe that if we are going to be the ones who elect our government representatives, we really should know how they're doing their jobs. And I will frequently refer to how much is being spent on this matter because it's public money and you have the right to know. I've only brought you up to October of 2019, and there's still a lot more to the story. But if you support the efforts that I've made since 2016 to try to hold police accountable and provide additional transparency, you can contribute to my cause through my website. But please stay tuned, because in episode 3, I'm going to take you through my first appearance at the Court of Appeal of Ontario. I believe that when I tell you what happened in 2020, you'll have a very clear idea of why I'm still fighting in 2023 to hold the police service accountable. See you next time when I pick things up at October 11th of 2019.